You may know that the Health Insurance Portability and Accountability Act of 1996, commonly referred to as HIPAA, governs the use and disclosure of an individual's protected health information, PHI. What you may not be fully aware of are the ways in which HIPAA's privacy rule governs how covered entities must respond to requests for PHI that are made in the course of litigation or other judicial proceedings. To refresh your memory, a covered entity, for purposes of HIPAA, includes health plans, healthcare clearinghouses, and healthcare providers. Often, a covered entity will receive a request for PHI in connection with litigation to which it is not a party. Even though the covered entity is not a part of the litigation which generated the request, it will still have obligations to respond in a manner that complies with both the statute authorizing the request and HIPAA's privacy rule governing the disclosure of PHI. It is vitally important for a covered entity to understand its obligations under HIPAA's privacy rule and any statute authorizing a subpoena or other requests for PHI. Failure to comply with HIPAA can result in fines and penalties imposed by the federal government or a state attorney general. This presentation will provide an overview and training on how covered entities must respond to requests for PHI made in the course of litigation or other judicial proceeding to which the covered entity is not a party. We will discuss the difference between a court order for information and a request for information, and will highlight the duties in responding to both in light of HIPAA's privacy rule. Finally, we'll examine other requirements that may come into play in responding to a request for PHI.